This call is now being recorded.
Hey, this is Randy Rosado, and I believe this is episode 5 of my Jailhouse podcast here, or whatever it is, my audio diary, whatever you want to call it. And today is, I think it's November 10th. Let me see, let me grab this newspaper. All right, November 10th. It's Wednesday, which I should know because it's peanut butter day, which is my favorite. Actually, I get a lot of peanut butter because I'm a vegan, and they give me a special diet, so that's pretty good. And apparently, it's the 246th birthday of the Marine Corps. So, yeah, I look at this paper and I just feel old, and I just watch the years go by like I'm rotting away here. Like a bunch of birthdays today. Tracy Morgan is 53. Ellen Pompeo from Grey's Anatomy is 52. Wow, she's 52? Okay. Warren G is even 51. Sinbad, 65. I remember I'd seen Sinbad in person years ago at a Macworld conference. I think it was New York City or Boston. I don't remember, but that's okay. And Mackenzie Phillips, I remember her. She's 62. She was from One Day at a Time. I used to watch that as a kid. Actually, I really watched it for Valerie Bertinelli. I thought she was so adorable. But anyway, yeah, I'm getting old, and the years are just kind of going by. And it looks like this Kyle Rittenhouse guy, this 18-year-old from Kenosha, Wisconsin, is about to start trial, or maybe he started trial. He killed a few people. He's from Illinois, and he went to Wisconsin and killed some people. And watch, he'll probably get less time than I got here for somebody else's paperwork. That's the amazing part. You know, just like this guy who killed George Floyd, this Chauvin guy, he got, 22-something years or something, and that's, almost half of what I got because some judges in Florida got pissed off at me. So it's kind of bizarre. I don't even know what to think anymore. Now we have this other Georgia trial with this Albury guy, probably butchering the name. Anyway, let me get rid of this newspaper. It's the same old stuff every day, politics and COVID. I just can't believe I spent the whole Trump administration locked up and all of COVID locked up, and shoot, by the time I get out, there'll be flying cars out there, it seems like. But anyway, I got quite a bit to cover today because I'm hoping to just have someone take a look at this. And I addressed all this in my appeal, but this is really the unlawful search in violation of the Fourth Amendment, the right to be protected in your private home from illegal search and seizures. And it's very blatant that there was an illegal search in my home, that the arrest was illegal. I've caught the state in lies. The New York FBI and the New York, the Goshen police are hiding from this. They won't even give us a copy of the arrest report. We've tried for over 5 years. So something is funny, and we've got evidence of it now. So again, I don't ask anyone to take my word for it because everything is documented. Unfortunately, some of those documents came after the appeal, but I don't think it would have mattered anyway. I mean, the fix was in. The appellate court was just as corrupt as the Lee County Court in the 20th Circuit. So, the second DCA was going to do what they were going to do anyway, and not even give an opinion as to why. But basically, my argument all along, and this was what I argued on the motion to suppress, was that the search warrant was not produced until more than 5 hours after they entered my home and began searching. Now, of course, they lied after the fact, and the main liar from the state of Florida was Robert Nichols. He was their investigator who came to New York to participate in the search and to try to be a big shot, along with his buddy, Robert Foley, who was an FBI agent at the time, just about to retire. He retired a few weeks later and became a prosecutor for the state. So this was all their little, their little inside work where they had called in favors and things like that. But there's a few things that happened because, he changed his story. First he said, and he interviewed my ex-wife just moments after the arrest. So they entered my home at 6 a.m. with keys from the landlord. So Nichols and the FBI agent in charge, Michael Howard, both admitted to using keys from the landlord and entering while I was sleeping, because he said, this way we can gain access. So they didn't knock, they didn't announce themselves, and right away that already spells foul play, whether they had a warrant or not. And I'm going to get to that in a moment, because I did argue that, and I showed plenty of case law and everything. So he went and tried to say, first he said they entered during a search warrant. As a matter of fact, he started interviewing my wife a few minutes before 7 a.m., and he said that you were shocked because we were invading. He specifically used the term invading. We invaded your home during a search warrant. Now, if he invaded our home during a search warrant, that essentially says they used the search warrant as a way to gain access. Now, when I was able to prove that the search warrant didn't exist until over 5 hours later, after 11 a.m., he changed the story and tried to say, matter of fact, he was also quoted during this interview with my wife. He also said, they're executing a search warrant over there. So not only did they use it to invade, so he says, my home to arrest me, he also admits that it's being executed. So they didn't wait until after 11 a.m. They started executing it right away, and he admits to that. And then later changes his story and says he was just using that as an investigative tactic, right? So it's really important because that already spelled out that it was an illegal entry. So I argued this at the suppression hearing, and Nichols doesn't deny it. He says, yeah, I went into your home at 6 a.m. Yeah, there was no search warrant at the time. So he already showed that he's a liar. And but during his testimony, he also said that he showed his Florida arrest warrant to the FBI, who verified it with the NCIC database. So what he's saying is there was an arrest warrant on June 28, 2016 when they entered my home, and that it was verified in the NCIC database by the FBI. Well, the problem here is that the NCIC registration didn't exist to more than 100 days later on October 8, 2016, and the court won't let us see it. They're purposely blocking it, and it just so happens the clerk of court's an alleged victim. So they won't let us see it, but we've got proof that it didn't exist until more than 100 days after the arrest. So Nichols, again, lied, saying that there was a Florida arrest warrant in the NCIC database. Now, the other lie is that they entered my home using the arrest warrant. First it was a search warrant, then it was the arrest warrant. Well, the problem is the search warrant wasn't executed until October 8, 2016 by the Lee County Sheriff's Office when I arrived in Florida. So more than 100 days later, this alleged warrant that was executed in June of 2016, June 28th, was not actually executed until October 8th. So again, I was basically kidnapped. There was no reason for that, for the arrest. There was no way to justify it, right? And then even at trial, when my attorney attempted to ask some other FBI agents about the NCIC, the court automatically blocked it and forbid him to say those questions. The state objected, the court sustained it, and my attorney was not allowed to ask the FBI agents about the NCIC. So this is crazy, and the Florida, the Village of Goshen Police in New York still have not provided an arrest report, and they refuse, and they keep ignoring these Freedom of Information Act requests. So this whole thing smells bad. Nichols says he didn't participate in the arrest, yet he admits to reading me my rights in a New York police station. So here you are, this Florida investigator, not even a real cop, he's an investigator for the state attorney who's the prosecutor, coming into New York like he runs everything, running into my house without a warrant, reading me my rights in a New York police station. Matter of fact, he was in Detective Ryan Rich's office because Rich just gave him carte blanche and said, here, do whatever you want. And this is what was going on. Now, and I documented this in my appeal. I showed case law saying, look, if you enter someone's home illegally, that evidence has to be suppressed. There's numerous laws from the second DCA, the state versus Ramos in 1981, Alderton versus the state in 1983. There's plenty of other cases that I showed. And then the state tried to argue at the suppression hearing that they were going to be able to access it through inevitable discovery, and they cited some McDonald case. But the problem with that is there's a couple prongs, a couple of things they have to meet for inevitable discovery, and one of those is they have to show that they have to prove they were pursuing this search warrant prior to entry. So prior to 6 a.m., they have to show that there was some kind of affidavit, something in place that the search warrant was already being pursued. And they also have to show exigent circumstances for that kind of entry. And exigent is emergency circumstances. So if it was hot pursuit and I ran into my apartment, if they thought I was destroying evidence maybe, or I had a gun in there, or I had a hostage in there, those are emergency circumstances where the police can run into your home without a warrant. Now that makes sense. The problem is there was no emergency. I was sleeping. They used keys from the landlord and entered while I was sleeping. I had no idea they were coming. I had no idea there was a warrant. Matter of fact, there wasn't a warrant, technically. So how would I would have even known that I was in trouble for anything? I was just living my life, not aware of what this corrupt Florida, that these officials were going to do. And then the fact that they got the FBI and the New York agents to participate is even worse. So now the judge turns around and denies the suppression. He ignores the state's inevitable discovery argument, and he says that it was a good search because of the arrest warrant. Now, so he's trying to again go off of Nichols' changed story that it wasn't the search warrant, it was the Florida arrest warrant. I already told you that the Florida arrest warrant didn't exist until October. It wasn't executed until months later. So we already know that that's a dead argument. But on just a couple months ago, on August 24th, 2021, the Orange County Jail actually responded to my FOIA request, my Freedom of Information Act request, and they provided me the documents. And you could view these documents on randallrosado.blogspot.com, and you'll see exactly what happened. And this shed a lot of light because even though I still have not seen the actual arrest report from the Village of Goshen, nor do I know if they officially arrested me because the FBI took me into custody and then handed me off to them and kind of passed me around like a hot potato. Well, this was the documents that the jail had. This is all I had pertaining to my arrest and incarceration there. And it was interesting because they changed the date of the arrest. It said June 28, 2016, and when it was scratched out, and it said September 7th, 2016. And I remember being in court September 7th, 2016 in New York because I was extradited about 20 days later. I think they picked me up around the 27th. Right, so my arrest date all of a sudden became September 7th and not June 28th. Well, then why was I being held in a New York jail from June 28th, 2016 to September 7th? But here's what was more interesting. The New York arraignment that happened on the date of my actual arrest, right, June 28th, 2016, they took me in front of this judge, Rory Brady or something like that. And the document says, and you can view this again at the blog. This is part of the Freedom of Information Act. It says violation of New York Criminal Procedure Law 570.34, and that's fugitive of justice. And that basically says that they can arrest me without a warrant. So now the New York charge and arraignment says I was arrested without a warrant. So what is Nichols talking about, and what is Judge Richards, that nasty, crooked judge in Charlotte County, part of the 20th Circuit, right next to Lee County? What are they talking about when they're saying I was arrested based on the New York warrant? As a matter of fact, the New York warrant doesn't even give. The Florida warrant doesn't even give New York authority to arrest me. As a matter of fact, it's addressed to all Florida law enforcement. But that's kind of irrelevant. The point is, the judge is lying. Nichols is lying, of course. The state knows about it. The state's been lying, and these people are criminals. The state even tried to extort me, and I'll show you that on another time. But here's the thing. Here's what it says. New York Criminal Procedure Law says a person in New York, well, in this state, may be lawfully arrested without a warrant, with reasonable information that the accused stands charged in the courts of another state with crimes punishable by death or imprisonment for a term exceeding 1 year. right? So if Florida could have shown evidence that I was already charged with some crimes, that could have justified the warrantless arrest. So if New York's arraignment is saying that I was arrested without a warrant, why are Nichols and Judge Richards saying that I was arrested first with the search warrant, and that changed to the Florida arrest warrant, which didn't exist until months later, right? Now, the other thing it says is Florida, the 570.34 also references 570.32 and says it's important because it says the person must actually have been charged with the crime in another state. So at the time of arrest, I would have had to have already been charged in the state of Florida, and that wasn't the case. There were no charges against me at the time. As a matter of fact, there was a fax to the Orange County Jail from St. Lucie County, not Lee County. Right now, I was arrested apparently because of these Lee County charges, but I guess because the paperwork was so screwed up, they couldn't get the New York governor to sign the extradition warrant. So what they did was they had St. Lucie file their arrest report and charges. They had them send it over, and that was dated, I think, August 24th, 2016. They faxed it to the Orange County Sheriff's Office, to the jail, and that's basically how they justified extraditing me. That's how they justified the charges to bring me to Lee County, but that was St. Lucie. So St. Lucie was basically trying to fill in the blanks for the Lee County mistake. But again, that's August 24th. I was arrested 2 months earlier on June 28th. So I was held for 2 months without any charges until St. Lucie decided to help Lee County out. And again, you could look at this. I'm not making this up, man. This is ridiculous, right? So then we go back to this alleged NCIC, and the NCIC wasn't filed until October 8th, 2016. And then when we pulled the report from the Florida Department of Law Enforcement, the FDLE report, it shows I was arrested on October 8th, 2016. So again, according to all of the records,
you have 1 minute remaining.
I was arrested on October 8th and not June 28th. So this whole thing has been a sham, man. I mean, not only was the arrest illegal, not only was I kidnapped, but the bottom line is the search should have been suppressed. All of this was done, and then I'm going to run out of time. I might have to finish this on another call. But then I showed the law because, matter of fact, I'm going to have to continue this because does the state of Florida, does a Florida court have the authority to rule on a New York search? So I'm going to talk about this again for a few minutes in the next segment because it's really important. So let me finish with that, and then I'll continue from there.
Thank you for using